Very good morning to everyone present here. Let's start with the Impact Lecture Session Series 2. The topic for the presentation is patent filing from brain to paper. The presenter is Dr. Sivanand, Head IPR Cell, Industry Interaction Center at Reva University. About Dr. Sivanand, he has initiated many MOU in exchange with Reva University and CCAM Incubation Center and ICAR Nived Nav Center and Siemens Trains. He has also organized 5-day FDP on IPR training program MOU in pipeline to have with Reva University. He before joining Reva University, he was working in CMR IT, where he was in charge for MSME Incubation Center and IPR. He has also filed almost 12 patent, 25 research articles, and he has submitted almost 15 research proposals, in which around 6 are granted. With this short intro, I hand over the session to Dr. Sivanand to enlighten the participant on IPR from brain to paper. Over to you, sir.
Thank you, sir. Share the screen, sir. PPT, is it visible?
Yes, sir.
Okay. Yeah, good morning to all. Dr. Dinesh Kumar, sir, I introduce briefly, and let us start the session. Patent filing and brain to paper, because it's very, very important, because as Indians need to innovate something, then brainstorm the new ideas and nurture that into POC. Okay, then once you reach the POC, then you can convert that into a product or prototype. Then you can implement it. Okay, in that process, you need to protect your IP. Otherwise, someone else can steal your know-how, and you are going to lose your monopoly rights for a particular invention. Sir, I'm not able to move the slides.
Sir, get back to normal mode.
Okay.
Yeah, sometime in Google Meet there is a problem.
Maybe. Okay, I'll move by normal mode. Okay. Content of today's session is vision IPR, then patent specification, drafting and filing, prosecution of the IP, then case. Let us discuss about case study. Okay. Vision to become a center of excellence in creating human resources in the field of intellectual property rights and establish an ecosystem of value-based knowledge in IPR. A mission to provide IPR awareness education to the faculty and students to manage innovation and IPR within the framework in the curriculum. To contribute for socio-economic development through IPR, because mainly by protecting intellectual property. Okay, see, if you want, you can become an entrepreneur by starting your own startups. Otherwise, you can commercialize your know-how after protecting to the investors. Again, it's a case to case. Okay, before taking a patent, okay, here no intellectual property rights or patents, okay, comes from some innovation or invention is nothing but things must be new or novel or original okay, that can be protected. Okay, if anything is exist in the public domain, that cannot be claim it as a patent, because here, based on your claims, your examiner will examine, then if they convinced after searching the public domain or patent databases, then they are going to give a monopoly rights in terms of granting for the year 20 years. Okay. Yeah, before that, okay, innovation or inventions comes from where? Okay, you need to brainstorm yourself by looking at the day-to-day issues in the societies or industry at large. Okay, here no fields are not restricted to innovate or invent. Okay, in the present scenario, it may be from craft, science, art, engineering, environment, product, modeling, fashion, graphics, etc. Okay, so many sectors, so many domains, and so many fields. Okay, from where we can generate the innovation or inventions. Okay, you know, in innovation, here just you are going to assume, okay, there if there is a problem, then how to solve the problem, you are going to find the solution by imagination. Okay, that you call it as an idea. Okay, looking at the problem, you are going to brainstorm in various ways or different approaches to solve the problem. Okay, how, what is wanted or needed by the society or by the industry people to solve the present or existing problem. Then once you define the problem, you are going to analyze it, then ideate by brainstorming. Okay, once you ideate, you are going for a proof of concept. Okay, that we call it design. Okay, once you reach the proof of concept, then you can start build the prototype. Okay, initial stage you can build a ugly prototype, then you can improvise it iteratively to reach the requirement set by the parameter set by the customer or end user or from the industry. Okay, okay, once you freeze the prototype, when it works at the level of customer satisfaction, then we can implement or deploy into the market. Okay, what is innovation? Here, newness or adding value, that we call it as innovation, right? Okay, it may be functional value or symbolic value. Yeah, functional value is nothing but technology driven. Okay, where some device or product or process, it will have its own functionality. Okay, that can be patented. That we call it as functional value of innovation. And if it is design driven, where only you can protect your design of its shape and configuration or aesthetic, ornaments, pattern, colors, etc. Okay. Then degree of newness, where there may be a radical innovation or incremental innovation. A radical innovation, okay, you can newly develop or which is not exist in the domain, and incremental innovation if there is a existing functional product or process where you can improve its efficiency, performance, or its functionality, etc. Okay. A new meaning, new concept. Okay. Here, these figures indicates the design, shape, and configurations. Okay, in various aesthetic look. Okay, that can be protected under Patent Act, Indian Patent Act, under design registration. Okay, creative new meaning with new innovation. Okay, here no, there is no restriction. Only thing is for getting the design registration granting by a patent office is that here whatever the shape and configuration which should not be exist in the public domain as on the date of filing the design registration application. Similarly, patent also. I'll take the patent later. Okay, this is the one case study related to innovation. Okay, here right side figure melting furnace, which is existing one and which has the opening at the top, and inside I can place the crucible to melt the raw material. I built another furnace for multifunctional. Okay, here this right side one is existing and functionality will be same as the first one, forging and melting as well as heat treatment furnace, which is built by me. Here cost for right side furnace was around 4 lakhs, and I built this furnace for the multi-function furnace for 55 lakhs. Okay, within 55,000. Okay, you just compare the economical significance between these two. Here, using melting furnace only, we can melt non-ferrous alloy up to 1200 degrees Celsius melting temperature. Here, you can use forging and melting furnace up to 1000 degrees Celsius. Okay, use it for melting the non-ferrous alloys as well as forging the specimens, heating the specimens for forging applications and heat treatment as well. Okay, can you see the design difference? I provided the door in the front in compared to right side furnace at the top. Okay, if you provide the door in the front side of the furnace, so it's easy to place the crucible or other component or heat treatment or forging component to heat it in. Okay, and also in this right side melting furnace, they provided spiral silicon carbide heating elements of 18 diameter, which consumes more power. That is more source of energy, and also cost will be more for the heating element. In this furnace, I implemented 14 mm rod type, straight rod type silicon carbide heating elements, which consumes less power, so that we can save the cost and energy. So that is what we call as innovation. Okay, you can compare cost-wise, then functionality-wise, and economical significance and industrial applications. Okay, right side is meant for only one application. Left side is meant for multi-function, like melting, forging, heating the component for forging application, and heat treatment also. Okay, now let us come to the today's topic. Okay, here when the topic mentioned it as brain to paper, so that I touch that innovation part also, because without invention, okay, there will not be a intellectual property protection, right? Okay, in that context, I added few slides related to innovation. Okay, now let's come to types of intellectual property rights. Here, patents, geographical indications, plant varieties, trade secret, industrial designs, layout design of integrated circuit, trademarks, copyrights. Okay, these are the types of IPR, intellectual property rights. Okay, here mainly in academic institutions, researchers are focusing on patents. Okay, a patent is a techno-legal document. Okay? The granted patent will have the monopoly rights to the inventors for 20 years. Okay. Here application, here I searched it in the Indian patent database. Only 2019-20 data is available in the published manuals. Okay. These are the patents filed state-wise by the Indian applicants. And subject to distribution of examiners of patents domain-wise and sector-wise. Okay, earlier had a few were there to examine biochemistry. Examiners might examine mechanical and metallurgy, but nowadays change the stuff. Then a particular patent goes to a particular domain or sector basis. Okay, here top 5 Indian applicants for patent in the field of information technology, and top 10 Indian applications for patent from scientific research and development organization, DRDO and CSIR, etc. A top 10 applications for patent from academic institutions and universities. I have not got present data, this data for the year 1920. Okay, now these lists might be changed. Definitely there will be changes in it, because in recent years most of the academic institutes and universities also inventing and filing more patents in the Indian Patent Office. Okay. Top 10 foreign resident applications in India. So these are the number of applications they file for granting the patents. Okay. Trends in 5 years respect to filing IP applications. Patent applications are more. Design, then trademark obviously count to be more because only trademark is meant for this one, no, symbols, character, text, okay, to showcase the brand name of the product. And GI, geographical indications, copyrights, that is literary work, and semiconductor integrated layout designs. Here, trends in patent applications, year-wise, filed, examined, granted, disposal to 1920. And design applications, trademarks, GI and copyright applications. Okay. Here, as I mentioned, here you can invent many, but all inventions are not patentable. Here, where there are subjectable subject patent matters are there. Okay, whatever the inventions you are making, then it should falls within the subject matter of patentable inventions. Okay, that why I put it as patentable invention. Can do that. Inventions comes from where? Either from research and development or design thinking, or from the innovation by observing the problems or identifying the problems in the existing product or process. Okay, here invention something that has never been made before, that we call it product invention, or process of creating something that has never been made before, that we call it as process invention. Okay, here invention and economic growth. Okay, that is demand driven. Here innovation is always demand driven. Here there is a demand, then people will be focusing to solve the problems by the industry people or to provide a solution to the public domain by solving their problem. Okay. Otherwise, because no, why do you want to put your effort, your know-how, intellect, and time, money, okay, to develop something? If there is a demand, then only you're going to put your effort along with material money. Okay, otherwise, it's of no use, right? That's why I mentioned it as inventions must be a patentable invention. Not all inventions can be patentable also. Okay, there must be some value added to the invention, then only it has meaning, otherwise it's of no value. Patents are monopoly rights, and these rights are scarce because industry people place and fight for monopoly rights. Okay, here major players, by protecting their inventions, okay, has monopoly rights to avoid others to make it or to do the business in the market. Okay, here invention, patentable invention, and patent specification. Okay, once you develop once you nurture the innovative idea into POC, into a prototype, okay, then you can go for start drafting the patent specification. Okay, here inventions equal to patents. Patents must have a novelty, inventive step, or non-obviousness, industrial applications, economic significance. If your inventions has these elements, okay, then that here these elements can be considered as a patent, then that invention can be applied for patent to grant. Okay, here innovators pursue patents in expectation of future profits. So today, okay, you're going to observe or identify problems in the industry or public or societal issues. Then if you solve that, then if you have the know-how in terms of patent by protecting, okay, in your innovation or invention, then it may give future profits to you. Okay, it is not now. That's why patent analytics is a crystal ball that can look into future success of companies and technologies, future rise and decline of industries, even future rise and fall of nations. Okay, that is the reason here always you need to innovate something to provide solution to the existing product or process, or If it is not existing, then directly you can call it as invention. Okay, then it falls under the patentable subject matter. Here requirements for grant of a patent. First one is subject matter patents under section 2 of 1J, 2 of 1JA, 2 of 1C. 3 and 4 are not patentable because section 4, that is atomic energy, that cannot be patented under Indian Patent Act 1970. Then novelty under section 2 of 1J, 2 of 1L. Okay. Here also invention falls under subject matter patents, then that invention must have the novelty or originality and utility or industrial applicability. That invention must be used somewhere, okay, as utility or industrial applicability. Then non-obviousness or inventive step. It means that the person skilled in the art must enable the invention, disclosed inventions, and he should feel that definitely there will be uniqueness when compared to existing product or process in the public domain. Okay, that falls under section 2 of 1JA. Then specification under section 10 and rule 13. Okay, where you are going to disclose about invention in terms of title of the invention, field of invention, background of the invention, then summary of the invention, brief description of the drawing, and detailed description drawing. Okay. See, after disclosing the functionality or connectivity of the product or steps of the process, then based on your invention, you need to protect in the form of claims. Okay. Claims must be there in the patent specification, then abstract, that limits to 150 words. Then if you have drawings, you need to represent the drawings separately. Okay. Why you should take care of drafting patent specification? Okay. Here, since it is a techno-legal document, okay, here based on patent rights for granting, otherwise it will be refused. Okay. Specification is what appears in public domain, because no, here whatever the disclosure they were going to specify it in as a patent draft. Then once you file it, okay, if you request for publication, otherwise by after 18 months by default it will get published in the public domain from the patent database. Okay, so that you need to take care while drafting the patent specification. Okay. Here no competitors, person with ordinary skill in the art and generally public may be among those who read the specification apart from the patent examiners. Okay, hence it is important to bestow extreme care while drafting patent specification, most importantly with respect to the language and structure of the patent specification. That is very, very important. As I mentioned, patent is a techno-legal document. Then here you have to give respect the language and structure of the patent specification. It is extremely important to use carefully selected language to describe an invention to satisfy requirements both in legal terms as well as in technical terms. These are the anatomy of patent specification. Patent specification must have start with title, then field of invention, broad area of the field of invention, then particularly specify the narrow down into your invention. Okay. Then background of the invention, that is whatever the inventions available in the public domain as an today, okay, that we call as prior art. Okay. Here background of the invention is available maybe in patent database or in journals or maybe in magazines, advertisement, or it may not be exist in the form of text. Product or process, services may be available in the public domain. It also we consider it as a prior art. Okay. Then summary of the invention. Here you need to summarize about your invention, okay, which is not there in the background of the invention. Okay, that is specifically related to your invention. Brief description of the drawings. Here you are going to give the figure number with caption to the representative of the drawings. Okay, because in diagram or representation sheet, drawing sheet, you are not going to give any caption to the particular views, where front, top or side views, okay, or section views. Okay, so that very briefly you need to describe about the drawing figures in the brief description of the drawings. Then detailed description of the invention, okay, where you need to disclose in detail about your invention, okay, so that the person skilled in the art or the person working in the same area or domain, he must be in a position to enable your invention, okay, without putting too much effort to do experimentation to develop the product or process. Okay, so a person skilled in the art should convince that your invention is having novel or original. Okay, then once you discover that, then in the separate new page or in the separate sheet, you need to write the claims. Okay, your claims, for your claims only will have monopoly rights, because a grant will be granted to based on your claims of the invention, not to the description and other component or anatomy of the patent specification. Okay, yeah, these things, anatomies are also important in patent specification, because it is going to disclose the description of the invention, but claims will have the rights as per Patent Act. Then in separate or new page, you need to mention the abstract that limits to 150 words. Then if you have the drawings, then you need to represent the drawings separately in separate sheets by giving name as FIZ.1, FIZ.2, etc. Figure number 1, 2, etc. Then sequence number, while drafting the patent, you are going to provide the sequence number starting from the field of invention to the detailed description of the invention. Okay, no need to give sequence number for claims and abstract drawings. Okay. For that, I want to touch this one. Here, invention is nothing but problem solution statement, right? Okay, there is a problem where you are going to brainstorm and provide a solution, okay, by putting your know-how, material, time and money. Then you are going to find the solution to the problem, okay, that you got a problem statement, problem solution statement. Okay, inventions, protecting the inventions by patents filing. Then after prosecution of the filed patent, okay, if it get granted, then you'll have the monopoly rights for 20 years for your invention. Then it may have high value. Okay, then if you want, you can commercialize it or transfer the technology by getting the royalty. Otherwise, you can start your own as a startup. Field of invention. Here, which is just an introductory statement as to what the invention is, which normally begins with the words the invention relates to. That is broad area of technology. First, you need to specify broad area of technology, then followed by particularly or specifically to the invention. In brief, okay. Then background of the invention. Here, invention has to be in some field of technology, otherwise it will not be considered as an invention, right? Then invention should fall within a broad area of technology. Background of an invention will describe the field of invention, and it would also have a prior art. As I mentioned, prior art is nothing but here whatever the know-how related to your invention till date. Suppose you are going to file the patent today, okay, from today onwards you'll have the priority date. Okay, whatever the know-how exists in the public domain till date, that you will call as prior art. Okay, your invention should not be a substantially similar or similar to the existing prior art. Okay. The broad areas of technologies could be mechanical, electrical, electronics, biotech, chemistry, computer science, etc. Okay. Here, in background of the invention, from where you can search the prior art. Here, where there are different databases, you can search it through eSpaceNet.com or WIPO, that is World Intellectual Property Organization, then Google Patents, then US Patent Database, eSpaceNet.com is European Patent Database, then IP India database. Okay, a type of searches: prior art search, novelty search, technology landscape search, FTO analysis, invalidation search, infringement search, and complete search. Where the different types of search are there. But these, whatever the databases I mentioned over here, okay, here no need to pay for searching the prior art using these database. Okay, here search process: find the gist of the invention, prepare keywords, do keywords search, then classification search. Because here search will happen based on the keywords. Here if we put one word, for example, computer, okay, you'll get more than 1,000 granted patents in single patent database, either in Indian patent database or Google patent or USPTO or eSpaceNet or WIPO. Okay. Next, summary of the invention. Here, summary is a solution of the invention. Okay, and also you got a mirror image of the claims. For the claims you are going to write, okay, that you are going to narrate it in a paragraph, that we got a mirror image of the claims, present the invention in a narrative form. Invention has restatement of the claims, and from the problem solution statement begin with one sentence statement of the invention solution. Okay, here claims are very, very important. As I mentioned, you'll have the rights for claims in your patent specification. Okay, here along with patent applications. Here patent various forms constitute while filing the patents. Form 1, 2, 3, 5, 9. Okay, I'll take it later. Okay, in which form 2, that we call a provisional or complete specification under section 10 rule 13. Okay, where in form 2 you are going to disclose your invention, okay, by representing the anatomy of the patent specification as I mentioned in the previous slide, like title, field of invention, etc. Okay, next, claims. Claims are the heart of the invention or patent specification, where you need to structure it very carefully, because here you have the monopoly rights for 20 years based on your claims, not for your description or disclosed in the detailed description. Your claims is a single sentence format, it can be independent or dependent format. Claims begin with capital letter, each element resides in the claim should be intended. Multiple claims are consecutively numbered. Okay, types: independent claim, dependent claim, multiple dependent claims. Okay, claims will have three parts, namely preamble, transition, and body. Okay, here preamble, that names describes the subject matter of the invention. It means that, for example, a coffee mug, that is the subject matter of the invention. A coffee mug. Okay, and may state an intended use or purpose. A coffee mug is the preamble. Transition: the coffee mug consists of a handle, okay, and other features in it, okay, to connect those things, where you are going to use the word called as a coffee mug comprises. Okay, the transition word comprises is the transition word in the claim along with the preamble. Coffee mug is a preamble, comprises is the transition word, and body of the coffee mug. Here body recites all the parts or elements, steps of the client inventions and how they interact. Here a coffee mug comprises, a preamble is the coffee mug, transition comprises, then body, okay, that handle with other features of the coffee mug. Okay, let us take another example. A chair comprising 4 wooden legs. Preamble: a chair. transition comprising, okay, then body, a four wooden legs. The other elements linked to a main invention. A chair is the invention over here. It comprises four wooden legs. Okay. Here, chair is the preamble of the climb. Transition, comprising is the transition. Then four wooden legs are the body of the preamble, that is main climb. Here, another example. A cheeseburger for consumption comprising first and second buns, a fatty positioned between said first and second buns, and a slice of cheese melted on said patty. Here you can observe a cheeseburger for consumption is the preamble of the climb. Okay, then comprising is the transition word. Okay, that comprise a cheeseburger comprises first and second buns, a fatty position between the first and second buns, and a slice of cheese melted on the said 40. Right, okay. Here no, first and second buns, a fatty position between first and second buns, and a slice of cheese melted on said fatty. Okay, these are the elements of the cheeseburger. Okay, those elements you call as body of the invention. Okay, your main invention or preamble of your invention is a cheeseburger, right? Okay. Here, instead of using comprising, if you use consisting, that limits, okay, limits to the other elements of the body of the climb. Because here no, here this entire thing is called as a independent climb or main climb. You can write and three dependent climbs with respect to the main climb if you use the word comprising. Okay. Here you might have observed, instead of using the patty, they used a, and here also used a slice instead of using straight away slice of cheese. Okay, because no, here there is no limitation if you use a or an in the elements of the body of the climbs. Body of the invention, okay, the main climb. Here if you use the, that limits, okay, you cannot go further. So if you want to disclose in detail further, then you have to use a or an in the element or body of the climb. Okay, I hope you got about preamble, transition and body in the climbs, right? Here, shall we write in a dependent climb by considering the first or independent climb? Anyone, please? You know, I'll write climb here. This climb 1, right? I'll write climb 2. Here, I'll take first and second buns. Okay, are used in a cheeseburger for consumption, consisting of made by what? Buns are made by what? Yes, come on, please. Hello?
Participant, please interact. Only then sir can have a better session.
Yeah. Yeah, first and second buns. Okay. Here, buns are made by some constituencies, some ingredients, right? Isn't it? Yes, come on. Participants. Okay, I'm writing second climb number 2. A cheeseburger for consumption consisting of first and second buns, okay, made by maida, yeast, etc. Okay, some other ingredients will be there, right? Okay, as climbed in the climb 1. If you mention as climbed in the climb 1, that second climb is dependent of a climb 1, right? Okay, and you can write climb 3 as dependent climb to the climb 1 as a patty position between the said first and second buns. Here now you need to talk about a fatty. A fatty is made up of what? Some ingredients, right? Then you can write another climb as climb 4. Third dependent climb to the climb 1, that will become fourth climb, a slice of cheese okay, melted on-site fatty in a cheeseburger is made up of what? Cow milk or goat milk or some other kind of cow milk, right? Whether, because no, so many companies are there, whether it is desi cow or hybrid cow or imported cow, right? Okay, that's how you need to write the claims. Preamble immediately stated at the beginning of the claims is the object of the sentence, a method of making coffee. Okay, the introductory part of the claim. Let us take one example. For a broad claim, vehicle. Okay, for a narrow claim, bicycle. If you invent a new bicycle, then if you want to start writing the claim, if you use the bicycle, that limits. Okay, then if you use the vehicle, it will become a broader claim. Okay, if the invention is related only to bicycle, then use of two-wheeler is more appropriate than vehicle. Okay, again based on the limitation of your invention. Okay, then you need to give the starting word broader or narrow claim. There are many companies now do not wish to include extraneous words in the preamble for fear of having the preamble being used to limit the invention. As I mentioned, no, you need to mention in a broader way, broader claim. Start with broader claim, don't go for narrow claim, because no, that limits, because legally it only limits to a particular invention, but you cannot claim further. For example, in operators comprising, operators is a generic word, right? Okay, there is no specific terminology over here. Okay, it's a generic, right? General, right? In operators comprising, okay, a method comprising or a system comprising. Okay, if you use these kind of things, there is no limitation to the invention. Okay, this indicates that broader claims. Okay, then you are going to narrow down to your specific inventions. A transition here, if you want to write the broader claim, that you use the comprises or comprising, or which comprises including or containing, characterized by, okay, broadest, open-ended. Here covers the specified component in the body of the claim. Also, an additional component consisting of or which consists of narrowest, closed-ended. If you use the consist of or consisting of, okay, that brings down to narrowing down to the closed-ended claims. If you want to elaborate further, for example, okay, if you take one element, any component or part, okay, which you have in the invention, you can say that a component or element, okay, comprises. If you use that word, then you can in the next dependent claim you can talk about a element or product or component further consisting of various features and also made by a specific material or made by alloy. You can specify the alloy percentage or composition percentage also. Okay, if you use the consisting of, which consists of, that limits, narrow down, okay, in the first or second claim itself. A transition, a claim with this transition protects only the specified components. If additional components are included, the claim is not literally infringed. To protect your invention in a broader way, okay, you have to use the transition word carefully. Okay, consisting essentially of or which consists essentially of intermediate in scope. Okay, if you use comprises or comprising, then that covers the broader sense. Okay, here body recites the various components required for the invention to be operable and patentable. It means that whatever the elements or components, okay, adapted in a product, okay, then you need to disclose elemental or component wise of its functionality and material, shape and configuration. Okay, everything it can disclose. Okay, it should define something that is new and inventive compared to the current body of knowledge. Process climb, the body is step 1, 2, 3, etc. If it is product, then body is element 1, element 2. Okay. You need to connect and relate each of element in the body. Body of the climb provides the element of the invention, as well as how these elements cooperate either structurally or functionally. Because no, patent is nothing but which covers product functionality or process functionality. If it is design only shape and configuration, that is aesthetic look, external look, solely that's why the eye or appeal to the eye, appeal by eyes, right? The drafter should also indicate how element interact with the other elements to form an operative technology. Because no, where there must be a elemental connectivity or continuity to perform its functionality, right? Okay, that's how you are going to assemble, okay, a mechanism to perform its functionality if it is product. If it is process, you are going to disclose step by step. Okay, these things already explained. Title must be as short as and specific as possible, should be the first phase of the specification. Okay. Then background of invention, already I mentioned, it covers field of invention and prior art. The summary, summarizing the proposed solution to the drawbacks cited in the background of the invention. Here no proposed solution to the drawbacks of the background of the invention is nothing but here whatever the know-how exists in the public domain as of now, okay, then you are going to find solution to the problem exists in the present in present situation. Okay, that is your know-how, your novel and original work, right? Okay, that is what here now summarize the proposed solution to the drawback cited in the background of the invention, because you are going to stating that so and so know-how is publicly available, but even you, and one more clue I wanted to give, don't compare your invention know-how with the background of the invention. Okay, don't disclose over there. Your invention disclosures starts from summary of the invention, brief description and detailed description. Okay, a detailed description, you are going to disclose your invention in detail so that the person skilled in the art must be in a position to enable your disclosure to make a product or process, okay, without putting too much experimentation or effort to make by too much experimentation. Okay, then claims specification must conclude with a claim, particularly pointing out and distinctly claiming the subject which the applicants regard as the invention. That is very, very important. Without claims, you will not get grants, because as I mentioned, you have the, as per law, you have the rights for your claims. Okay, there are more than one claim. However, multiple inventions cannot be claims under one patent applications. You can file additional application as different invention. Okay. Your abstract, a brief no more than 150 words, must commence on a separate sheet, preferably following claims. After the claim sheet, you start writing the abstract, limits to the 150 words. Okay. Drawings required where it is necessary for understanding the subject matter to be patented. Okay. Drawings gives more clarity while disclosing inventions in the detailed description. Okay, so that for the publics or the person skilled in the art or for the patent examination, okay, he'll go through the drawing, then he may understand better, okay, as disclosed in the detailed description, okay, to check the novelty or originality and other inventive steps, okay, for granting. Requirement of disclose specification as per section 10 rule 13 as well as section 2 of UNAPAC. Okay, it means that section 2 of UNAPAC, that is included subject matter or patents. Okay, and insufficiency of disclosure of person skilled in the art unable to make or use the invention is a ground for refusal of the grant of patent or ground for revocation of the patent if granted also. Okay, here most of the times people just, if they have an innovative idea, then by imaginary things they are going to represent the drawings and flowcharts, then disclose something. Okay, here it's an intangible property. A physical entity is not required most of the time, so that since it's intangible, people are going to write it as a patent specification or file it. If it is get through and get granted, then later if there is an insufficiency of disclosure or person skilled in the art unable to make or use the invention is a ground for refusal or oppose the grant for revocation. Okay. Yeah, how to start with patent process? Conception of an idea, patent search the prior art, then draft provisional and complete specification. Here provisional means if you have an innovative idea, then you are going to brainstorm to find the solution to the stated problem statement. Then immediately you can write one paragraph, okay, how you are going to solve the stated problem statement. Okay, then immediately you can go for filing it as a provisional patent. That provisional patent protects your innovative idea, okay, so that it will get the priority date, the date on which you are going to file it. Okay, then it will have the 12 months time to complete the invention. You can work it on your innovative idea, then you can disclose it in detail as complete specification. Okay, fees will be same, no need to pay once again for while applying complete specification if you file the provisional patent application. Okay, then filing patent application, once you drop the patent specification, then you can enter the detail as title, applicants, inventors, name with address and communication, corresponding address for communication in form 1. Here form 2, you are going to disclose your invention under complete specification. Form 3, I'll take it later. Okay, here then once you file the patent application, you can request for early publication, and provision is there now. Okay, then within 1 or 2 weeks your filed patent application will get published. Okay, if you request for early publication, for that you need to pay 2,500 rupees. For filing provisional or complete specification, you need to pay 1,600 online. Okay, or for early publication 2,500. And if you want to go for expedited examination, early examination, for that, if you are a natural person or if it is ordinary application, then you need to pay 4,000. Fees will be mandatory if it is expedited examination, or after before 18 months you're supposed to go for request for examination. Until unless apply for request for examination, the examiner, patent office examiners will not take your filed published application for examination. Okay, a time duration will be there. Till that time it will be there. Otherwise, after that your application will get abandoned. Okay, here once it is examined, then you'll receive the first examination report from the patent office based on the objections raised by the examiners, patent examiners. Okay, we need to reply back to the patent office, okay, by clarifying against the objections raised by the examination report. Okay, if they convinced about your reply, then for your reply, then it will go for granting. Otherwise, they are going to refuse it by giving the reason. Okay, then once it is granted, then you need to registration for granting, then you need to pay fee. Every year you need to renew the granted patent. Okay, then that is renewal and working the patent. Okay, once you have the grant certificate, then you'll have the monopoly right for 20 years. Okay, then you can start transferring the technology or commercialize it, or you can start your own, and also you can protect your intellectual property. Okay, how to start with drafting specification? If there is a reviewer, then receive the IDF, that is invention disclosure form from the inventor. Then read and understand the invention. Then prepare first draft. Then get the first draft reviewed by the proofreader. Send the draft. Okay, etc. Yeah, these are the forms. Here, no fee structure will be available in the patents manual. If you go to IP India official website, where you'll have the manuals and guidelines, the fee structure will be there. They just as I had mentioned, fees for natural person for filing the application 1,600, and request for early publication 2,500, request for expedited examination 4,000. Okay. Here, what are the forms you need to have while filing the application? Form 1, application for grant of a patent. That is must, where you are going to mention the title of the invention, applicant's name, inventor's name with address for communication, and all applicants and inventors address and email ID, contact details. Okay. Then form 2, provisional or complete specification. Okay, in form 2 under section 8 rule 13, where you are going to disclose about your invention, okay, along with claims, abstract and drawings. In form 3, statement and understanding. Yeah, you need to give statement and understanding about the invention of your invention. Then form 5, declaration as to inventorship. You need to declare as an inventorship. Okay, here in form 3, you can assign you can assign to the applicants. Inventors, here no, where there are two things, inventors are different and applicants are different, then inventors has to assign to the applicants. Otherwise, if the inventors are the applicants, then no need to declare. Okay. Form 5, declaration as to inventorship. Then form 9 for request for publication, early publication. At the time of filing the patent application along with complete specification, we can go for request for publication by paying a fee of 2,500, so that within 2 weeks your filed patent application and disclosures will get published into the public domain through patent database. Then form 18 or 18A, if you want to go for expedited examination, if you have a novel work or invention that is original and having a market potential, a USP and MEP, minimum viable product, then if you want to expedite the patent prosecution, then at the time of filing the application itself, you can apply along with form 9, request for early publication, and also form 18A, request for expedited examination of application for grant by paying the fees 4,000 for examination. Okay, 4,000 plus 2,500, 6,500 plus 1,600 for filing the complete provisional or complete specification. Okay, this is the total fee. Then if it is a registered small entity or startup, then you need to file form 28 to be submitted by the small entity with every document for which a fee has been specified. Okay. Here nowadays, no, whatever the natural person fee is there for ordinary application, same fee will be holds good for form 28 if it is small entity. Okay, now fee has been amended from the Patent Act. Okay, no need to pay extra for that. to encourage the budding entrepreneurs and startup peoples. Okay. Yeah. Here, if anybody wants, I'll offer consultancy for the patents, drafting, prior search, and copyright design registration, reply assistance to examination report, and awareness program, training program for academic and corporate organizations. You know, here, as I mentioned, to draft a patent, since it is a techno-legal document, you need to take care while using the terminologies, technical terms as well as legal terms. With this, thank you all. If you have any questions, let us discuss.
Thank you, sir. Thank you very much for the wonderful session. You started as like you started from the brain and finally ended with how to be drafted in paper. The basic question I have here is like most of the people while going for patent filing, they just approach some attorney. It is mandatory that we should go to an attorney to file our patent, or it's
No,
like
sir.
yeah.
Not required. You see,
Okay.
if you put little effort on existing patents or granted patents available in the public database,
Okay.
then if you go through, then I can search the closer prior art related to your invention.
Okay.
Then no need to go for patent attorneys. Here, patent attorneys they knows about legal stuff.
Hmm.
Here, two things are there. One is technical part, other one is legal, right?
Okay.
If you know both, then it's easy to draft the patent specification.
Okay, is there any specific course like to be attended to understand how to, because like when we are pursuing like one or two sessions, like we may not be fully completely versed of how to file a patent.
Yeah, yeah. Yeah, it's true because no, most of the sessions are like awareness programs.
Yeah.
You know, if you attend this one, no, drafting core courses, then it's easy to draft the patent because so many inventors they know about their know-how, but they may be lagging in writing or structuring the claims and drafting the specification.
Exactly.
But yeah, in our institute, I initiated
Okay.
which is what we organized in the month of first week of August, from August 1st to 5th. I invited industry, academia, then legal expertise,
Hmm.
okay, to showcase this one, no? How to write the claims and how to draft the specification.
Hmm.
Yeah, total 5 days FTP have.
Okay.
But it is not online, it is offline.
Okay, mostly yeah, that makes a clarity. And about the technical terms, because even we have filed a patent, but obviously like we have went through an attorney. They were
Yes.
using some technical words like it's
Yeah, yeah, yeah.
thereof.
Yeah, there are embodiment,
Yeah.
embodiment.
Yeah.
Yeah, you need to use few things because no, in legal course also,
Hmm.
because no, as you know, our specialization wise, domain wise, sector wise, technical terminologies varies, right?
Yeah.
Likewise, in legal also few terminologies varies. So since it's a techno-legal document, you're supposed to use those kind of words like there are way, wherein, and then embodiment. Comprises consisting of those things must be there, sir.
Oh.
Yeah, that is the reason people are approaching attorneys because they well versed with those kind of legal terms.
Hmm. So what will be the time gap, sir? Like if you start a patent, maybe let it be a design pattern. If I'm going to go for a design pattern where I don't want to clarify anything, like what will be the time period for publishing? Granting it may take time, but for publishing, yearly
Yeah,
publish.
but if it is a design registration, no, actually in India, in foreign they call it as utility design patent.
Okay.
Design, but in India we don't call it as design patent. We call it as design registration
Okay.
because no, it is you are not going to disclose any functionality of the device or product.
Yeah.
Only you are going to represent its features dictated solely dictated by the eye on the object.
Okay.
Okay. then you are going to claim only shape and configuration, that is external aesthetic look,
Okay.
okay, not inside the product or mechanism or functionality.
Okay.
Okay, so that will be, you can straight away get the design registration grant within a month or two. Okay, based on the this one no, type of or domain, in which domain you are going to specify, because various classes are there. Okay, depends on the applications queue in the database.
Okay.
Okay, they'll examine accordingly. Then less number of applications are there. Then within a month or within a 2 weeks also, you may get a grant. Yes, for design, because I have 3-4 design registration grants.
Okay. So within a month, like it is possible.
Yeah. But because no, for design registration, only you are going to represent the front view, top view, side views, bottom and top views, right?
Yeah.
In the representation sheet, and you are going to claim the shape and configuration, not the mechanism or working principle.
Exactly. Sir, is there any?
I can, if you have the drawings, new drawings, designs, then I can help you out.
Yeah, sure. Is there any cost difference between, a design pattern or a prototype?
Yeah, definitely. Because no, if it is patent is different. Patent cost is more. For design registration, only 1,000.
Okay.
That's all. There is no this one. No, there is no other forms. Only one form is there.
So
One form along with representation sheet. That's all. And then no need to apply for publication or examination. See, by default, they'll examine and they'll send, if there is any query or objection, they'll send the report, otherwise they'll publish it. If they're publishing the design means, it means that it's granted one.
Sir,
if you come to design registration.
Okay, what is the difference between design registration and patent, sir? Like, because being an academic institution, if we go for a design registration, will that be considered as a patent filing or?
No, sir. Actually, patent talks about functionality, entire functionality of the invention, which provides a solution to the problem, right?
Okay.
But if you come to design, design will have its own value added. Things like, commercialization. Suppose, if you are going to buy a ring, you are going to look at the aesthetic, right? Like it's design, right? Glass, this one, no? The glass or this growths are there. Something is there, right?
Yeah.
Any watch or any ornaments or glass pattern, you are going to look at the design, no? So it is related to those kind of things. Shape or configuration, ornaments, colors, patterns, or lines. It may be 2D or 3D. Okay. Design covers these things. Patent is nothing but you are going to disclose its functionality. Okay. Any product or process, it has to perform its function. And provide a solution to the problem. But in design, you are not. It is not going to perform any functionality, right?
Exactly.
Yeah, that is the difference.
Okay, sir. Then there is one participant, Vikas Sharma. He has some question. Mr. Vikas Sharma, so you can go with that.
Yes. Yeah. Good morning to all. Presentation was very nice. I have also learned two of the things which are like preamble and transition. These are the new terms for me. Sir, I have two interesting question. Like anyone want to file a Australian patent. So what is the procedure for that? Do any Indian can patent openly, or I have to hire a patent attorney for this?
Yes, sir. You see, you can file your own directly if you go through their patent website. Okay, definitely there will be guidelines. Usually when you go for other country publication from one country citizen, first you have to file your patent in own country, then you can go for other country filing, because you need to convey to the resident country. That is a procedure. And also there is some global patent, we call it as Patent Cooperation Treaty, PCT. If you file PCT, then you can enter into any national space, any country of interest where you are going to do business. Basically, industries are going to file the patent in different countries because they have the business in various countries. Because now, suppose if you have the patent grant in Australia, you are going to file the patent application along with patent specification in Australian country, right? Then you'll have rights only in Australia, okay, for your patent, granted patent, monopoly rights over there. You cannot claim it in India. Suppose you are filed the patent in Australia, okay, if it get granted from Australian Patent Office, then same for your invention, other competitor start the business of your know-how by copying, okay, by studying your technology, okay, then you cannot claim over here because you do not have a prima facie document from the patent of Indian Patent Office because no patent law is applicable to a particular country.
Okay. And what is the fee structure? Like, we have very nominal fee structure here in India, but
Yes.
what about Australia?
Because no.
And what I'm getting from you, like, it is a very difficult task for an individual to file that Australian patent. Like the difficulties, like you spoken the term PCT, so that is
Yeah.
a new kind of thing for the Indian patent filer.
Yeah, yes, sir, it's true. But as I mentioned, no, either you can go through PCT, Patent Cooperation Treaty, or directly you can file other countries' patent office also. But the thing is that no, fee will vary country to country because no fee structure will be there as per their economy. That is rupees. No, in India rupees is there, right? As for Australian currency, we need to check it out. Because mainly I'm focusing because I'm working towards academic institutes. Most of the academicians are now filing in the Indian Patent Office because no, these things are considering it was the various accreditations such as NIRF ranking, ARIA, Kapila, etc. Okay, and NBA also, NAAC accreditation. Okay, see if you file it in Australia, Indian accreditations may not consider those granted patents for their accreditation. It seems I'm not clear, but still discussion is going on. But I heard that if you file the patent in Australia, the prosecution is faster than India.
Okay. So thank you very much. Only I have last question. You give an example of ornament like ring.
Yeah.
So suppose a design is already there in the market in the patent database,
Okay.
and I have some innovative material with me, but design is same. So that innovative material will be counted as design patent, or it will be the innovative part.
So thing is that no patent, as I mentioned, shape and configuration. If the shape and configuration is substantially similar to the prior art existing this one no domain, if it is existing in the public domain, then that cannot be applied for this one no granted as a design registration. But changing the material, if there is a functionality, then you can go for patent.
Okay.
But see, as I mentioned, no, any product it has to have a function, some functionality. Then only you can go for the patenting. Otherwise, but the same material changing and just changing the material and shape and configuration same, then you cannot, sir. Because no, you are not in design, no shape and configuration. You are claiming shape and configuration. You are not talk about its functionality or material. Material and functionality come into the picture where any product or process having its own problem solving. This one, what do you call it as problem solution statement. There is a problem statement. There is a problem statement. You are going to provide a solution to that. Where we can consider change the material, because if you change the material, definitely there will be a change in its properties and significant economical significance, right?
Okay. So, thank you very much, sir. Yes, sir.
Yes.
Thank you, sir. Participant, any other participant, you have any other queries? Any other participant who has any queries? Okay. Okay. If no further queries, like I'll just have one last question if you don't mind, sir.
Yeah, please.
Yeah.
You ask any number of questions. No, no.
Because like I just have this doubt till people say like we are filing on a design pattern, but you say it's a design is not going to give you any solution, so that cannot be counted as a pattern. But I hear like maybe I may be wrong also, but what they especially mean by a design pattern, sir, actually?
So design registration, see, in the market, you're going to buy any product, right?
Okay.
Okay. It's a pack, outside package will be right, and the symbol brand name will be there.
Yeah.
Okay. You know where for the same product, okay, the same product is kept in various designed packing. Okay, then usually our mindset, okay, going towards a attractive kind of product
Exactly.
package, right? That also we call it as the design of the that pack,
Okay.
not inside the product.
Yeah.
And product also. So if you are going to buy a toothbrush,
Okay.
okay, you're looking at the that brush and its flexibility, handle, and while using also it's flexible. No, that should not harm to the teeth or gum, right? Yeah, that is one. Those things comes under design.
Okay, sir. Okay, sir. Thank you, sir. Thank you for the wonderful session. Like, I hope the participant got the insight of like how the patent filing has to be done, and maybe like now they might have got some confidence that we don't need an attorney, because like paying attorney is like by paying an attorney we can file 3-4 patent extra as the cost you have mentioned. Like by paying for attorney cost for one particular patent, we can go for 4-5 patents. It was a wonderful session to hold you on this morning. Thank you very much for your time, sir. Thank you.
Thank you. Thank you very much.
Thank you, sir. Participants, like the next session.
Shall I leave, sir?
Yes, sir. You can leave, sir. Thank you, sir. If you want, you can tell me. Thank you.